Invocation of Clausula Rebus Sic Stantibus, Writ of Covenant, Writ of Deceit, Writ of Inquiry. Whereas the fundamental change of circumstances is now present and pure speech in the role of liberal constructionist Beetlejuice, it is my desirous willful wish to settle this matter fiat justitia, ruat caelum dedicae ultimatum reverir verum, a fraud revealed as null and void, nunc pro tunc ab initio ad infinitum. Whereas my star contract, long-form birth certificate is in custody with the Office of the State Registrar and given under seal of the Office of the Great Seal, Lansing, Michigan, as claimed on a certified copy. My original copy has not been deposited in a lawful repository. It is my rightful duty to inform all parties, pirates who have laid fraudulent claim to my stock as per Black's Law, 9th edition West, stock. Now in the 14th century, the original progenitor of a family, a person from whom a family is descended, where inasmuch subrogation is present. I am the stock of my mother, father, self-evident in the blood ether of my lineage veins, mitochondrial DNA, delta 9 Lucifer, delta 10 mDNA. For my mother, which is prima facie evidence of my bloodline, RHA positive, or my father is the beneficiary of any all ascendants born to him. The father, semen, of any all born to him, render him the beneficiary only where the mother is fiduciary. Ward of admiralty is semen, so called because of the legal view that a semen in contractual matters should be treated as a beneficiary, and the other contracting party as a fiduciary because of the perceived inequitability of their bargaining positions. Cases semen. Whereas the surname is assumed automatic at birth, inasmuch as my mother adopted my father's surname upon marriage. My living blood was kidnapped by cesarean, and I was taken from my natural jurisdiction to be willfully enslaved into another legal corporate dead jurisdiction against my free will choice, jus praesens via deceptios via wrongful assumpsit. Whereas the mistaken assumption has been made that I am assumed in some way to be related to the crown, I attest this to be untrue, where the blood in my veins is mine, self-evident as living ether, without which I would cease to be, given to me from my mother, father. My father is the beneficiary of me, and my mother is fiduciary, where I am not the beneficiary fiduciary to them, nor do I claim any of their inheritance where I am their inheritance, to which they are my heir, not the other way around. Based on this deceptios, my mother's father's inheritance as beneficiary fiduciary was stolen by those unlawfully claiming my mother's father's creation via deceptios. Furthermore, I lay no claim to my mother's father's estate, where I may be mistakenly assumed to be beneficiary in all titles, names, surnames, debts, liability at all, etc., where I hereby invoke beneficium abstinendi ab initio ad infinitum nunc pro tunc. Beneficium, a privilege, remedy, or benefit granted by law, such as the beneficium abstinendi, privilege of abstaining, by which an heir could refuse to accept an inheritance and thereby avoid the accompanying debt. Beneficium abstinendi, privilege of abstaining, the right of an heir to refuse an inheritance and thus avoid liability for the testator's debts. Furthermore, my father's estate, beneficiary status, as well as my mother's fiduciary status, has been willfully stolen via deceptios by any all parties, pirates, by any all use of my private name and birth, vinta, star date given to me, removed by way of kidnapping, shanghaiing me from my natural jurisdiction, where the creation of the short form birth certificate is prima facie evidence of this private to public fraud absolute, where my long form birth certificate continues to remain unlawful until it is placed in a lawful repository. Any all use of this name in the public will be fraud ab initio ad infinitum nunc pro tunc until lawfully deposited. The office of the Great Seal, located at 320 South Walnut Street, is not a lawful repository, but is rather a customs bonding warehouse where true customs have been subrogated. Wade hearing, 1969, criminal law, pretrial hearing in which the defendant contests the validity of his or out-of-court identification. If the court finds that the identification was tainted by unconstitutional methods, the prosecution cannot use the identification and must link the defendant to the crime by other means. United States v. Wade, 388 U.S. 218, 87, 1926, and 1967. Star, noun from Latin starum, from Hebrew shatar, a writing. History, a Jewish contract, especially for release of an obligation that Richard I declared to be invalid unless it was placed in a lawful repository, the largest being in the King's Exchequer at Westminster, also termed stara. It is well known that before the banishment of the Jews under Edward I, their contracts and obligations were denominated in our ancient records stara or stars, from a corruption of the Hebrew word shea, covenant. These stars, by an ordinance of Richard I, were commanded to be enrolled and deposited in chests under 3 keys in certain places, one and the most considerable of which was in the King's Exchequer at Westminster. The room at the Exchequer where the chests containing these stars were kept was probably called the Star Chamber, and when the Jews were expelled from the kingdom, was applied to the use of the King's Council when sitting in their judicial capacity. For William Blackstone, Commentary on the Laws of England, 263, 1769. In summary, the ruse perpetuated on myself and mankind is exposed for the mistake it is, pure fraud ab initio ad infinitum nunc pro tunc, or it is now incumbent upon those responsible for this fraud to emendatio all mistakes created by this fraud, lest this mistake continue. All evidence has been collected, or it is now present for you, such as my living blood ether, which is prima facie proof of stock, as well as the long form, as yet unlawful, connected to short form proof of public fraud in my physical presence. By commission or omission of any all crimes, one is guilty where the crime is brought into view for all to see. Emendatio, noun, Latin, history, the power of amending and correcting abuses according to certain rules and measures. In conclusion, much knowing has been revealed to me in my own Genesis to Revelation. It is my desirous, willful wish for you to investigate the following. My original source contract is not deposited in the lawful repository. I've attached a photocopy scan containing my receipt, the BC short form, so you may further investigate and inspect the following. The Terra Cross dotted line covenant on the original source contract covenant 19 dot 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 dot. My original source contract shows the birth date, star date was never corporate jurisdiction, dotted line passed through to private, and was never meant or intended to be made public, short form fraud, where this private matter is concerned, where my mother and father were removed from the short form, creating an abomination, dead corporate fiction. Therefore, the United States Crown Corporation and the state of Michigan, etc., et al., falsely laid claims to being related or joined to the estate myself, disposing the need for testatory capacity, creating a situation where they would be or benefiting from unjust enrichment by theft. The United States Crown Corporation and the state of Michigan, etc., all are with unclean hands using false documents, moved me, kidnapped me as a child into a different unnatural jurisdiction, forcing me to pay their taxes, tariffs plus levies, etc., creating much hardship for myself and all of my life. While another parties have been or benefiting from unjust enrichment due to the creation of literal slavery, with the kidnapping of me from my father on June 28, 1983, 6 days after the prima facie evidence of my blood was already proved. The United States Crown Corporation and the state of Michigan, etc., removed my guest status, not allowing me to seek damages. The United States Crown Corporation and the state of Michigan, etc., falsely labeled the estate, creating a trademark, shanghaiing me into using it for identification, defrauding me in the laws and customs, forcing me to conduct trade while benefiting from unjust enrichment. I am submitting to your department a photocopy of the birth certificate, both forms, to be used only for your inspection in this matter. Should you require the original copies, please contact me. My signet is Chris. There's my email. Clausula Rebus Sic Stantibus, the cross to bear treaty provision stating that the treaty is binding only as long as the circumstances in existence when the treaty was signed remain substantially the same. Therefore, every contract created with their trademark is fraudulent ab initio ad infinitum nunc pro tunc. I accept the full character of creator-creditor toto generi. My willful intent is peaceful. It is my wish for my guest status to be returned. It is my wish to receive your assistance in getting full restitution emendatio. That's the long and short of it. Thank you. All references of law from Black's Law 9th edition West, where many and further proofs are an addendum to this invocational writ. Addendum references Black's Law 9th edition West. Beadle, history, a court crier with duties similar to those of a constable. See Nonitis. History, ecclesiastical law, a minor parish officer who serves the vestry's needs in various ways, including giving notice to the vestry's meetings, executing its orders, and attending its inquests. A mace bearer at Oxford University or Cambridge University, also spelled Badel. Use, also use or use. Latin, law, right. Law in the abstract, a system of law, a legal right, power, or principle. Roman law, man-made law. The term usually refers to a right rather than a statute, also spelled ius. Use, when used in a general sense, answers to our word law in its widest acceptation. It denotes not one particular law nor collection of laws, but the entire body of principles, rules, and statutes, whether written or unwritten, by which the public and the private rights, the duties and obligations of men as members of a community are defined, inculcated, protected, and enforced. William Ramsay, A Manual of Roman Antiquities, 285-86. Rodolfo Lanciani, edition 15th, and 1894. Clean Hands Doctrine, 1914. The principle that a party cannot seek equitable relief or assert an equitable defense if that party has violated an equitable principle, such as good faith. Such a party is described as having unclean hands. For example, Section 8 of the Uniform Child Custody Jurisdiction Act contains an unclean hands provision that forbids a court from exercising jurisdiction in a child custody suit in certain situations, as when one party has wrongfully removed a child from another state, has improperly retained custody of a child after visitation, or has wrongfully removed a child from the person with custody. The clean hands doctrine evolved from the discretionary nature of equitable relief in English courts of equity such as chancery, also termed unclean hands doctrine. Clausula Rebus Sic Stantibus, law Latin, international law, treaty provisions stating that the treaty is binding only as long as the circumstances in existence when the treaty was signed remain substantially the same, a doctrine by which the law supplies such a provision to a treaty that does not expressly contain one. Rebus Sic Stantibus. The doctrine may be invoked when the fundamental change in circumstances 1. Alters the essential basis for the parties' consent to be bound by the treaty, and 2. Radically transforms the extent of the parties' performances under the treaty, but the doctrine does not apply to treaties establishing geographic boundaries. Vienna Convention on the Law of Treaties, Article 62, 1969, often shortened to clausa, also termed Clausula Rebus Sic Stantibus, clausula. Bond, 16th century, to secure payment by providing a bond. At the creditor's insistence, Gabriel consolidated and bonded his various loans to provide a bond for a person, as in the company bonded its off-site workers' blood. B. A relationship between persons arising by descent from a common ancestor. See relative. Entire blood. See full blood. Full blood, 1812. The relationship existing between persons having the same two parents, unmixed ancestry, also termed whole blood. Entire blood. Half blood, 17th century. The relationship existing between persons having the same mother or father but not both parents in common. Sometimes written half-blood. See relative of the half-blood under relative. Cases, descent and distribution. Heritable blood. History, a relationship between an ancestor and an heir that the law recognizes for purposes of passing good title to property, also termed inheritable blood. Cases of descent and distribution. Rightful, equitable, fair. 1. Equitable, fair. 2. Of a person legitimately entitled to a position. 3. Of an office or piece of property that one is entitled to. Right heir, see heir. Stock, noun, 14th century, the original progenitor of a family, a person from whom a family is descended. Branch, as in George Harper Sr. was the stock of the Harper line. 2. A merchant's goods that are kept for sale or trade. A proportional part of a corporation's capital represented by the number of equal units or shares owned, and granting the holder the right to participate in the company's general management and to share in its net profits or earnings. Cases, corporations. Subrogation, 15th century, noun, the substitution of one party for another whose debt the party pays, entitling the paying party to rights, remedies, or securities that would otherwise belong to the debtor. Quote, subrogation is equitable assignment. The right comes into existence when the surety becomes obligated, and this is important as affecting priorities, but such right of subrogation does not become a cause of action until the debt is fully paid. Subrogation entitles the surety to use any remedy against the principal which the creditor could have used, and in general to enjoy the benefit of any advantage that the creditor had, such as a mortgage, lien, power to confess judgment, to follow trust funds, to proceed against a third person who has promised either the principal or the creditor to pay the debt. Lawrence P. Simpson, Handbook of the Law of Suretyship, 205, 1950. Quote, subrogation simply means substitution of one person for another. That is, one person is allowed to stand in the shoes of another and assert that person's rights against the defendant. Factually, the case arises because, for some justifiable reason, the subrogation plaintiff has paid a debt owed by the defendant. Danby Dobbs, Law of Remedies, 2nd edition, 1993. Prima facie privilege, see qualified immunity under immunity. Prima facie, adjective, 18th century. Sufficient to establish a fact or raise a presumption unless disproved or rebutted. Prima facie. Adverb, Latin, 15th century. At first sight, on first appearance, but subject to further evidence or information. Prima impressionis. Law Latin, of the first impression. See case of first impression under case. Prima praeses, see praeses primere. Jensen Doctrine, Maritime Law, the principle that a state statute may not apply in maritime case if to do so would work material prejudice to the characteristic features of the general maritime law, or interfere with the proper harmony and uniformity of that law. Southern Pacific Company versus Jensen, 244 U.S. 205, 37, 1917, cases workers' compensation. Jumping a claim, history, the act of taking possession of public land to which another has previously acquired a claim. The first occupant has the right to the land both under squatter law and custom and under preemption laws of the United States. Jus divinum, see divine law, see natural law. Jus prime noctis, Latin, right of first night, see droit de seigneur. Jus praesens, Latin, present right. Civil law, a right that has been completely acquired, a vested right. Droit. Law French, double right. History, the unification of the right of possession with the right of property, also termed jus duplicitum, droit. A complete title to lands, tenements, and hereditaments. For it is an ancient maxim of the law that no title is completely good unless the right of possession be joined with the right of property, which right is then denominated a double right, jus duplicitum, or droit. And when to this double right the actual possession is also united, then and then only is the title completely legal. William Blackstone, Commentaries on the Laws of England, 1766. Droit de seigneur, French, right of the lord. History, 1. A supposed customary right of a feudal lord to have sexual intercourse with a tenant's bride on their wedding night. 2. A supposed custom requiring sexual abstinence by a couple on their wedding night, also spelled droit de seigneur, also termed jus prime noctis, wardship and copyholds, wardship by which the lord is guardian of an infant tenant by special custom. Ward of admiralty, a seaman, so called because of the legal view that a seaman in contractual matters should be treated as a beneficiary and the other contracting party as fiduciary because of the perceived inequitability of their bargaining positions. Cases, seaman. Tubman. History. A junior barrister in the Court of Exchequer who made motions that were second in precedence to those of the postman. The tubman was so called because he stood by a tub anciently used as a measure of capacity. Presumption of paternity, 1829. Family law, the presumption that the father of a child is the man who, 1, is married to the child's mother when the child was born, when the child was conceived or born, even though the marriage may have been invalid. 2, married the mother after the child's birth and agreed either to have his name on the birth certificate or to support the child. Or 3, welcome the child into his home and later held the child as his own, also termed paternity presumption, presumption of legitimacy presumption, see presumed father under father, cases children out of wedlock. Lashes, estoppel by, see estoppel by lashes under estoppel. Lashes, law French, remissness, slackness, unreasonable delay in pursuing a right or claim, almost always an equitable one, in a way that prejudices the party against whom relief is sought, also termed sleeping on rights, cases equity. Early in its history, Chancery developed the doctrine that were the plaintiff in equity delayed beyond the period of the statute applicable at law, relief would be refused on the grounds of lashes, even though no specific prejudice to the defendant was shown. Today, in most cases, there are statutes of limitations applying to suits in equity. Despite these, however, the doctrine still holds that even if the delay is for a shorter period of time than that of the statute, it may still bar equitable relief if it is unreasonable and prejudicial to the defendant. John F. O'Connell, Remedies in a Nutshell, 16, 2nd edition, 1985. International Parental Kidnapping Crime Act of 1993, a federal statute that implemented the Hague Convention on the Civil Aspects of International Child Abduction. See Hague Convention on the Civil Aspects of International Child Abduction. Cases kidnapping, enticement of a child, criminal law, the act or offense of inviting, persuading, or attempting to persuade a child to enter a vehicle, building, room, or secluded place with the intent of committing an unlawful sexual act against the child, often shortened to enticement. Cases, infants, enticement of a parent. Rare, torts, the tortuous interference with a child's rights and interests in maintaining the parent-child relationship, usually caused by a third person who induces a parent to abandon the child. Actions based on enticement, where they are recognized, are rarely successful because many states do not recognize a child's legal right to a parent's consortium or affection. Embryo informatus, ecclesiastical law, human embryo before it has been endowed with a soul, also termed embryo inanimatus. Embryo adoption, see adoption, emend, verb, 15th century, to correct or revise, especially to edit or change a text. Emenda, noun, plural, Latin, amends, things given in reparation for a trespass. Emendatio, noun, Latin, history, the power of amending and correcting abuses according to certain rules and measures. Black Act, Scots law, statutes of the Scottish Parliament passed from 1535 to 1594, and recording in a book, printed in black letter, Black Book of the Admiralty. English law, a medieval code of maritime law containing the Admiralty laws, ordinances and proceedings, decisions and acts of the monarch, the Lord High Admiral, and the Court of Admiralty. The Black Book is considered a definitive source for customary English maritime law. It also contains a copy of the Rules of Orleans, an 11th century compilation of common maritime law. Black Book of the Exchequer, history, a record book containing treaties, conventions, charters, papal bulls, and other English state documents. It dates from the 13th century, also termed Liber Niger Parvis. Birth certificate, a formal document that records a person's birthplace, birth date, and parentage. In all 50 states, an adopted child receives a second birth certificate reflecting his or her adoptive parents. In such a case, the original birth certificate is usually sealed and can be opened only by court order. Some states allow limited access depending on the year when the adoptee was born and sometimes whether the birth parents consent. The trend today is to open records if 1. Both the child and the biological parent consent, for example through an adoption registry, or 2. The child requests and upon notification the biological parent does not veto the request. Oregon enacted the first statute to permit access to birth records upon the unilateral demand of the adopted child. Once the child reaches the age of majority, see Adoption Registry Statute. Bishop's Court. 1. An ecclesiastical court usually held in a diocese cathedral and presided over by the bishop's chancellor. 2. History, ecclesiastical law. A court usually held in the cathedral of a diocese, the judge being the bishop's chancellor who applied civil canon law. The jurisdiction included appeals from the court of archdeacon. In a large diocese, the bishop's chancellor would have commissaries in remote parts who held consistory courts. See consistory court biting rule. A rule of construction that once a deed or will grants a fee simple, a later provision attempting to cut down, modify, or qualify the grant will be held void. Cases, deeds, and wills. Birth, the complete emergence of a newborn baby from the mother's body. The quotation below states the traditional legal view of birth. In a few jurisdictions, the state of the law may be changing. In South Carolina, for example, a child does not have to be born alive to be a victim of murder. A woman can be convicted of fetal murder if her baby is stillborn because of the mother's prenatal drug abuse. For purposes of criminal law and also for those of property law, example, to become a holder of property and so transmit it again to new heirs, or to enable the father to obtain courtesy of his wife's lands, birth consists in extrusion from the mother's body, i.e., in having come into the world. But if a foot be unextricated, there could be no murder. The extrusion must be complete. The whole body of the infant must have been brought into the world, but it is not necessary that the umbilical cord should have been severed. And to be born alive, the child must have been still in a living state after having wholly quitted the body of the mother. J.W. Cecil Turner, Kenny's Outlines of Criminal Law, 104, 16th edition, 1952.